Okay, today we're talking about crimes. Crimes are wrongs against society, offensive conduct that destroys the order and peace of the community. These are so dreadful we use force, for example prisons, arrest, to deter them. So people don't want to be arrested, people don't want to be thrown in prison, they don't commit crimes, right? So here we move away from compensating the victim, which is what torts is all about, to actually deterring crime. Also, there is an element of punishment involved there, in that certain victims feel that they want to see the criminal suffer. I lost my son, this man is responsible for it, he did this crime, he shot him, he stabbed him, he killed him somehow, and I want to see that man suffer. So there's a retribution element which we don't like to talk about too much, but there's also this deterrence element, which is a very reasonable kind of thing to do. We don't want people committing crimes. And so there are certain things that are not crimes. Bad manners, being rude. There neither may be crimes nor wrongs in a tortuous sense. We aren't compensating people for, oh well, the person did something, stuck his tongue out at you. We don't generally think that's going to be rising to the level of a wrong. Did it cause you emotional distress? It's usually too common to think that that's the kind of thing. It's just not extreme enough. Unethical behavior, okay, again, they're not crimes. There's just some things that are not covered, some things that are wrong, some unethical things that people do that are not defined as a crime or a tort. So we're not going to punish them as a crime. We're not going to allow for compensation. And generally, they're not generally going to be thought to be all that terrible. They may be very, very common kind of things that people do that we say, well, these are not nice people, but we're not going to actually punish them, or are we looking to compensate their victims? Then, then most torturous acts are not considered to be crimes. People are not prosecuted for crimes usually when there's a tort. For instance, a jurisdiction might have a criminal trespass statute that very rarely is invoked. People are sued for trespass by the owners, and generally the police and society, the officials don't want to pursue these matters because it would tie the police up too much with matters that are not all that important. But one can bring criminal trespass charges where somebody has broken in, and it's particularly offensive. One might do that, but it's generally not brought. Prosecutors might add those charges just to give them sort of bargaining leverage with criminals who might want to bargain. So I had a client who was drunk, and when he was drunk, he was jiggling at a gate of an apartment building. There was a little wooden gate out front. It was an old converted house that had been converted into apartments, and he was trying to get past the little lock on the gate and couldn't do so because he was drunk. He was perhaps going to burglarize the place. He was a man who had been convicted of robberies and burglaries in the past, and the police officers who arrested him charged him with both public intoxication, which is a misdemeanor, and criminal trespass in the first degree, which would have been a minor felony. Maybe get a 1 or 2 year sentence on something like that. And they quickly dropped the trespass charges. Oftentimes that's the case. They're not looking to convict people on trespass charges when the owner can bring criminal action. So most torturous acts, defaming somebody is not usually going to be a crime. There are, in some countries, crimes of defamation. And in England had it, but we don't generally have it because truth is a defense. The English statute basically made any terrible thing you said about a Queen's official a crime. Okay, so that's the Zinger case. We've talked about that before, I believe. Unethical behavior, I talked about it. Parking and speeding tickets are not crimes. However, There are crimes that one can commit by driving and have to involve usually a vehicle. So vehicular homicide is a felony, and also drunken driving, and there's rage. These are statutes that have recently been passed, were not very common or didn't exist in the early part of the 20th century. So these are all kinds of new things, and so there are some cases where certain kinds of things have been made criminal that involve vehicular violations. Okay. Charging of a crime. Charges are brought by either a government prosecutor on his own. He can decide to bring a crime. He'll usually do so on information. The information might come from the police officer, frequently it does, and also, but it might come from a citizen who files a complaint. And he can bring charges based on those if he thinks they're credible. And he usually thinks that the police are credible if they say that, oh, you know, this guy was doing this, he's going to usually file those charges. Information from a citizen might depend upon the stature of the particular citizen, whether or not he believes that. Because, I mean, he basically has a lot of discretion on whether to bring crimes. He can instead refer it to a grand jury. If he doesn't want to declare it a crime himself and bring it as a crime, he can refer it over to the grand jury, which is unlike the jury that you see in a jury trial, which is called the petit jury. It's a small jury, okay? The grand jury is usually composed of more people, maybe 20 people, 30 people, and it was, citizens who would decide on whether or not a person should be charged with a crime. They wouldn't decide upon whether there was guilt or innocence. That was not what they were charged with doing. They were charged with whether they believed he had committed a crime, whether or not they believed there was evidence he had committed a crime. So basically, they're not going to be finding guilt. They're just going to be finding that we have reason to bring this case against this person. So that's a grand jury. Many people say that the prosecutors exercise a good deal of control over these grand juries. They're basically given evidence by the prosecutor. The defendant is usually called to testify on his behalf. He can present evidence, but usually these are fairly quick as opposed to a regular trial, so they occur really quickly, and so it's not considered to be the same quite as a trial. And one must charge a person within a reasonable time if one is going to charge somebody with a crime. Everybody has a right to a speedy trial, so these things have to be done rather quickly. Okay, proving of a crime. Basically, the accused is presumed to be innocent until proven guilty. That's very basic to our system. So it's part of due process. We'll talk about due process as being one of a bundle of rights that you have in terms of when you're being tried. And one of them is that the jury will be instructed that you are presumed innocent until proven guilty. So the prosecutor has the burden of proving that guilt with credible evidence, which could be testimony, could be also physical evidence like a gun with fingerprints on it that was a murder weapon. It could be it could be actually even expert witnesses who are going to testify as to the person's mental state. Prosecutor must prove the elements of the offense as set out by statute. The burden of proof is in a criminal trial is of course beyond a reasonable doubt. You remember that in a tort case, in a civil case of any sort, whether it's tort, contracts, or a proceeding before an administrative court, it's going to be more probable than not. So O.J. Simpson was tried and found not guilty by a jury, and he was nonetheless, after that, I'm going to say prosecutor, he was actually, a case was brought against him by the father of Ron Goldman, who was killed in the murder at the same time that O.J.'s wife was killed, and O.J. was suspected of the kill. So Ron Goldman's father brought his own case and hired his own lawyer to pursue, sue him because he thought he had gotten away with murder. Okay, and he was very upset, and he was willing to spend the money. It wasn't the money. He wound up getting a huge judgment from O.J. Simpson, but he brought a case, and the charge was that he had wrongfully murdered him. That was a tort charge, so wrongful death. And The jury in that case found that he was more probable than not liable for the deaths of Ronald Goldman and actually the wife too, but and issued an order that O.J. was going to have to pay. Was it $25 million? It was a huge sum, and O.J. didn't have enough in the bank account. However, he would have enough in his retirement fund, but under California law, which he was a California citizen, and the case was a California case, under California law, they can't touch these retirement monies. So retirement monies are protected from these kinds of proceedings, criminal proceedings even. So they couldn't get to that, but he remained liable for that sum, and he continued for years to be liable for that sum. I have no idea whether he actually paid it all off. He had ways of making money, signing and going, making book deals and making, selling memorabilia or signing autographs and making appearances. I think he didn't do quite as well as he was hoping to do with that, because he was not as popular as what he had been before the trials. Anyway, burden of proof is beyond a reasonable doubt, so you need to keep that in mind. Beyond a reasonable doubt means that, let me try to explain beyond a reasonable doubt. For instance, in the O.J. trial, there was some talking head, I think, that said that maybe O.J. had been committed by a Colombian drug ring because he had had his throat slit from ear to ear. Well, that may be a kind of thing that the Colombian drug ring does, but there's a number of people who murdered people who were not connected with the Colombian drug ring, so it's not very dispositive. It's not very good evidence that this was a Colombian drug ring. And there was nothing else to indicate Colombian drugs were an issue. They tried to make an issue out of nothing, basically. I think there were people who speculated that O.J.'s wife was killed by aliens. That comes out of left field. Those are the kind of things, both of those are the kind of things that are not credible evidence, and therefore if you were a juror and you were to tell me that you voted for him as not guilty because of either of those arguments, I would tell you that these are not reasonable kind of things, and we should retry the case, and you won't be on it next time. Maybe next time we'll ask people about their believings about aliens coming in and interfering with our processes, sort of like the Russians. Nowadays, maybe somebody would say the Russians did it. I don't know. There's no evidence that any of those parties did it. You have to have some credible proof if you're going to use that as a mitigating factor, as a factor indicating he's not guilty. You have to have something. If your defense has to have credible evidence, just as the prosecution has to have credible evidence, something that tends to show that actually O.J. is guilty or is not guilty. Maybe it's evidence that somebody else is guilty. Yeah, if you got evidence that aliens had actually come down and killed those people, well, okay, let's see that evidence. I'm going to like to see that evidence. Any evidence tending to exonerate the accused must be turned over to him by the prosecutor and the police. They cannot keep that evidence to themselves. They work for the citizens, and the person who's being prosecuted, O.J. Simpson, he's a citizen too. So he deserves their evidence. If they got evidence that tends to show that he's not guilty, they should turn it over to him. And he'll be asking for discovery of evidence, and they need to be forthcoming with it. If they don't have to ask for it specifically. If they have evidence and they think, well, this tends to show he's perhaps not guilty, it's not conclusive, but it's some evidence that supports his not being guilty, they have to turn it over. And so you'd have a retrial on that. That's a big enough deal that you could get a retrial if there was evidence that was not produced that the prosecution had. They don't have to actually produce it in court. They don't have to bring it into evidence. They have to allow, though, the defense, the attorneys for the defendant and the defendant, they have to allow them to know that this evidence exists and turn it over to them. So any evidence tending to exonerate the accused must be turned over to him by prosecutor and police. Now we're going to talk a little bit about some due process right, just in a very general kind of way. We're not going to be getting into details too much on this, just trying to give you an idea of what we're talking about. Very first one is a very important one, these due process rights. Now this is a partial list, this is not all your due process rights. There's a lot more than this, these are just some of the important ones. Right to confront hostile witnesses, or any witness for that matter. You have a right to confront a witness that's testifying against you, making bad evidence against you. Sometimes you don't want to, actually. We usually call this cross-examination. So the prosecution calls a witness. The police officer who found the bloody gloves is called to the stand, and then you have a right to question him as to the circumstances under which he picked up the glove, as to his attitude towards blacks. And that was a very crucial kind of thing in the trial, as was the bloody glove, actually. And many people thought that was sort of like the nail in the coffin, but it turned out not to be. And also a call, he has a right to confront hostile witness, but he has also a right to call or subpoena his own witnesses. So the court will order witnesses on his behalf. If he needs a witness and the witness doesn't want to voluntarily come in and testify, he can get a subpoena. And if he hasn't been able to get the witness to come, he thought the witness would come, then he wouldn't come, then he could ask for a continuance until the witness appears. So you have a right to all the evidence that you can to make your case, because it's about a search for truth. It's not supposed to be a game that the prosecutor and the defense attorney play. Okay, and so he has a right to examine and challenge other evidence. So that gun, he has a right to examine that gun, have that gun examined by an expert. If there's a bullet, he has a right to look at the slides they made of the bullet, what their forensics show, and have experts, his own experts, look at it. And if there is blood evidence, DNA evidence, he has rights to have DNA experts look at it. He has a right to bring in expert witnesses who know about how a crime scene should be, handled. And that was used very effectively by the OJ team. They criticized very harshly the LAPD's procedures. I don't think they were as bad as some police departments, but they definitely made, I think, some mistakes maybe. But it was a big trial, and things can happen. Dogs can wander in there and do things. So you have to keep this crime scene, sort of pristine, and it's a very important duty, so that both the plaintiff, both the prosecutor and the defendant can look at that crime scene and maybe see things in the light of that. Maybe you want the actual jury to go to the crime scene and look at it. Either side might want them to look at that crime scene to see certain things. A right to demand a jury of his peers. So you have a right to a jury trial. In any capital case, you have a right to a unanimous jury. Now, there are some jury trials in which that are criminal trials, even felonies, that don't necessarily require a unanimous jury. In other words, you don't get a hung jury. So you heard about maybe hung juries, where one juror could hang up the jury so that they can't come back with a verdict because it's not unanimous. And so they'll come in and they'll maybe say, Your Honor, we cannot come to a conclusion. And the judge will say, Are you sure? And he may even send them back and say, Well, make sure you can. Try again. So because otherwise maybe he's thinking, I'm going to have another trial on the case. And that's really not something that they want to do easily, because it's costing the taxpayers money, isn't it, to have these trials. And so, if everything was otherwise okay with it, but you have a hung jury because you have one defendant, this is one of the reasons why when you call a jury in a capital case, a murder case, and you're going to ask them, the defense attorney is going to ask them the prosecutor is going to ask them what are their views on capital punishment. If the state allows for capital punishment, and it's something that they could come back with, then they have a duty to come back in the appropriate case. If they believe, the prosecution's case has made a case for murder in the first degree without any extenuating circumstances, they might well say, well, we should come back with murder. And so the judge may ask them about what they are. Maybe they could come back with a second-degree murder or manslaughter. Anyway, a right to demand a jury of his peers. And to voir dire, we talked about voir dire when we talked about torts. Voir dire is asking the jurors questions, like we just talked about the question where you asked them whether they oppose the death penalty, and kick them off if they are, because they're not able to perform the function of a jury. They're not able to do all the things that a jury can and should be able to do. And there are other kinds of things. If there's any kind of prejudice, I think I told you I kicked off one lady from a jury because she was the wife of the prosecutor. I thought that was likely to cause her not to be an impartial witness. And the judge had no trouble, even though he was the hanging judge, he had no trouble. He kind of smiled and laughed a little bit, and he said, yes. Now, how did I know she was the prosecutor's wife? She had the same last name, and I asked her, do you have a relationship with this prosecutor? That I named him, and she said, yes, I'm his wife. I said, okay, I have no more questions for you. And she knew too. She smiled. She was getting off. And and to challenge that jury for its, maybe being prejudiced. And you'll have a certain number of prerogatives, peremptory challenges, we call them. Peremptory challenges are challenges that you can just say, we don't want this witness, and that's it. So you get maybe 6 of those, and you get a jury pool of maybe 30 people, 20 people, I don't know, and then you kick them off. And if you kick off, if too many people get kicked off, then they'll add more people to the jury. They got them out there, they'll bring them back in, they'll bring them in, they'll bring in substitute jurors. If during the trial, one of the jurors gets kicked off for misconduct, or he's been tampered with somehow, somebody said something to him, and he says the court, clerk came and said things to me about the trial. It's not supposed to do that. Okay. Or the other attorney said something to me, and or I saw a news item that talked about the trial. There are oftentimes, especially in a trial like O.J. Simpson's, you don't want the jury looking at outside evidence, so-called outside information, outside reports of what the trial is. The evidence is filtered by the rules of evidence to keep out prejudicial evidence and to keep out any evidence not relevant, and just to have good evidence presented. So we have these rules for evidence, on the other hand, a magazine like Time doesn't have these rules of evidence in mind when it's publishing their newspapers. They want to sell as many copies, and if they decide they can sell more copies by making O.J. a few shades darker than he actually is, then they'll do that. And the trouble is that some people will view a darker defendant as being more likely to be guilty, and so that would be a grounds. If a juror was to say, "Well, yeah, I read this article," in some sense, it doesn't even matter what he might have voted or what he says he thought about it at the time. It's just tampering. It's tampering with him. Anyway, challenge objectionable. You have a right to challenge objectionable evidence. One of the things is that gun. There has to be the jury, the prosecutor has to establish how the gun was handled, who had the gun, how they handled it, making sure that it hadn't been tampered with, and nobody did anything to the gun that would, invalidate it as evidence. So there's these rules on how they handle these items that they want to put into evidence. And they know what the rules are, and they usually follow them. But in some cases they don't. In some cases they flagrantly violate them. There are cases where maybe a police officer gives an accused a glass of water. He asks for a glass of water. This officer goes and gets him a glass of water, and he takes the glass and he removes with plastic, Scotch tape, I think it does. It just removes, or is able to remove the man's fingerprint, and then he plants that on the gun. So there's been proof that has been done. And so sometimes you might have these kind of things. And we wonder why we get so many black defendants that are wrongfully convicted. Okay? Because we have some police officers who are not really interested in doing justice, who think they know who's guilty and who needs to be punished. And this is wrong. Challenge objectionable evidence and argument. And so, it's not just simply the evidence that can be objectionable, but also the argument. So I think I maybe told you I had this one drug defendant who, during the trial, the prosecutor had called him an enforcer. But he was not an enforcer. He had watched the enforcer's back. He was a very good friend to the enforcer. And the enforcer would go in to get some guy and beat him up maybe. And he'd tell David that you stay out here, and if the police come, blow your horn. Okay. So he wasn't doing any enforcing, but he was helping the enforcer. They could have presented that evidence. That's nothing wrong with that. But to call him an enforcer, that was impermissible argument. And it's wrong, clearly wrong. However, the three panel judges who reviewed the case on the Circuit Court of Appeals, Federal Circuit, found that it was harmless error, that it probably didn't have much effect, that he would have been convicted anyway, because there was certainly plenty of evidence that he had participated in, not the enforcement maybe, but he had participated in the drug conspiracy. He had sold heroin and cocaine numerous times and recruited people to work for the drug company, you could say. Okay. So objectionable evidence in argument can be, a point. So that's the kind of thing that could possibly have overturned the case, but they said it was harmless error because it didn't really amount to much when given the great weight of evidence that was already against him. So he was convicted for 10 years and remained in there for 10 years. My point was that I felt it was prejudicial, highly prejudicial I think you can't throw a skunk into a jury box. And I didn't invent that phrase, but that's one phrase that can be said about something like that. They know better than that. Right to representation by his counsel. So they have a right to representation. And nowadays, at first in our country, and certainly in the 19th century and even the early part of the 20th century, we really didn't concern ourselves much with that until Brandeis said that we ought to be giving these poor people some. It's silly to talk about a fair trial if the defendant doesn't really have competent counsel to represent him. He's representing himself, or he's got some clown representing him, or he can show that the licensed attorney was not really doing his job, wasn't up to it, was drunk or something. I don't know. He could get the trial overturned. So Brandeis made that argument, and 20 years after he made the argument, they adopted it. So it was in a dissent of Brandeis. So this is the importance of dissents, that sometimes people like Brandeis are able to somehow make a very strong argument, and that argument reverberates. It goes down, and other people are talking about it. Other dissents are read by other judges who have read his dissent and agree with it. And first thing you know, society's onto it, and generally the court changes its mind because of this growth in the protection of it. So Brandeis was known as a great dissenter because his dissents often wound up being adopted later in later cases, usually years and years later, decades later, 40 years in some cases. Whitmer case of free speech was like that. Right to representation by his counsel. Okay, right to represent. So that's an important right. I mean, basically the people don't know what to object to. They don't know what due process is, and so how can they object to things that are objectionable? They won't recognize it. You might have the same problem with your attorney. Maybe your attorney doesn't know it, but you're stuck. If you've taken an attorney, you're stuck. If they appoint an attorney to you, if you decide he's not any good, you can ask for a different counsel, and they'll usually give you a different counsel. I don't know how far they'll go in allowing you to change counsel, but you can ask, or you can ask to defend yourself. If you really can't find one that's any good, you say, well, I'll just defend myself. Some people do very well with defending themselves. One person who did very well with defending herself was Angela Davis, who was a poet, and she wrote a lot of protesting about the handling of criminals, and they prosecuted her for a crime. I don't really know much about the case in terms of what she was charged with, but I know that her defense lawyers, she had defense lawyers, decided that she was good enough to put her own case on and thought the jury would be impressed with her that way because she made a very good representation. She was a teacher and had, quite a good spiel, okay? Anyway, so she defended herself very well. But usually defendants, even intelligent defendants, don't really do too good. So, you have the case of a Dutch doctor who married the Heinz heir. So she had inherited the Heinz fortune, you know, the ketchup company, and he was prosecuted for murdering his wife, who died from an overdose of insulin. Okay, so she had taken an overdose of insulin, and he was able to defend himself. He was not able to. He was convicted, and then he had a retrial. And on the retrial, he won a retrial, and you usually get that because of some mistake made in the trial itself, some evidentiary mistake or other mistake. And on the retrial, his lawyers told him not to take the stand because his Dutch accent sounded like a German accent, and the jurors had all grown up watching movies. At that age group of jurors would have been very influenced by the concept of anybody with a German accent has got to be a bad guy. You know, so you can get psychologists to testify that. Corporate officers often cite studies of these egregious cases. So you know, we're talking about there is on PBS there's a plea documentary found on Frontline's website. And you know, so corporate officers often cite cases of these egregious cases to support their own claims of prosecutorial abuse. Seems like sometimes the people who you wouldn't expect to be the ones to use these defenses will do it. Classification of crimes, we've already talked about felonies and misdemeanors and violations. So you know what those were. We talked about that when we talked about the dog statutes. Let's see whether I can. Types of crimes. Act without intent arises by statute. So you have criminal negligence statutes. So it might also be a crime, negligence. The vehicular homicide is a form of criminal negligence. Destructive negligence, where you know, negligence is seen as fraud. You know, so you find this sometimes with accounting crimes, where you know it's thought that the accountants or the corporate officers were committing fraud on the shareholders, even though what they did was just negligence. But you know, they have a high duty towards them, and so it can be construed as being a crime, as being the same as fraud. Most crimes have common law roots but are now codified. Specific intent crimes, mens rea crimes, no specific intent. So basically, criminal negligence statute might be a reckless failure to take reasonable precautions to avoid foreseeable harm to others. Elevates a misdemeanor or a lesser felony to a serious felony. And we saw that with the dog statutes, right? A failure to keep dangerous dog penned up as required by statute or court order results in a victim's death. The misdemeanor dog attack state statute is elevated by the federal law to second-degree murder charge. So we talked about that before. But it's not bad to remind when we're talking about it in terms of crimes. Strict liability crimes. Statutory crimes expressly requiring no guilty mind or specific intent. Proving of non-compliance is all that is required. For example, statutory rape. So it doesn't matter the girl was 15 and the boy was 14. He's guilty of statutory rape. She can't be guilty of statutory rape because the statute doesn't define it that way. You know? And so it's a minor girl. And so it depends upon the wording of the statute. So it's very textual, isn't it? You know, and this society doesn't want young ladies to be seduced, assaulted by young boys. And even though it may actually, the boy might be saying, well, she was somehow complicit or even the primary mover, which I believe in some cases that may well be the case. You know, but obviously there's a concern. Usually women would be more concerned about getting pregnant, and therefore there's more of a concern that they might be involuntarily forced into having sex. And so you would have to prove rape. Okay, and that's not so easy to prove, as we saw in the hearings with Brett Kavanaugh. So basically she was alleging she'd been assaulted. What's that? That's rape. Okay. Possession of a named drug laws. Failure to restrain a viciously dangerous animal. You know, that's a statute, like we said it was. Possession of named drug laws. So you got statutes on marijuana, possessing heroin, possessing cocaine. People have been picked up on these charges and wound up in prison for years, especially in the South, and they're black. So specific intent crimes, these involve a state of mind where the accused intends an express malicious result to follow the prohibited act. Example of these crimes require proof of specific intent would be arson, burglary, child molestation. So you got to prove that he intended these kinds of things. You can bring child molestation with, say, I've heard of, I had a friend of mine who represented a defendant who was accused of statutory rape with a 12-year-old girl, and his argument was that the girl had seduced him or had solicited him for sex. And there are some girls who unfortunately are maybe in the hands of the wrong people that maybe do that, and that he didn't know she was a minor. But that's not really an excuse, because statute says he can't have sex with that kind of a girl. Anyway, false imprisonment, first-degree murder, forgery, larceny, theft, solicitation. These all require an intent. If you're going to charge somebody with murder, he has to have an intent to commit murder. He has to want to kill the person. He usually has to plan it. And you know, you're going to want to prove that he had planned it, and it wasn't just an act of impulse. So if it's something that just kind of, he comes in and he finds his wife in bed with another man and he kills them both, he's got the defense that it was, you know, manslaughter. He was just terribly upset by it. Or if the guy attacked him and he killed him, he's got defense, right? So you're going to usually have to show, with murder, there's usually going to be oftentimes a showing that there was a plan to murder. Maybe the wife goes out and hires somebody to kill the man, and so she plans this with this person who's supposed to kill the man. He doesn't kill the man. He turns out he's actually an undercover police officer, and he turns her in for attempted murder. Okay, and that's also a specific state of mind. She wants to kill him, but you know, this is not the way to separate. Anyway, forgery, larceny, theft. So all these, you need to have that intent to do the terrible act that causes the harm. Attempts to commit a crime of specific intent are also called specific intent crimes. Nowadays, we have moved away from these, and also mens rea crimes also, to the MPC Model Penal Codes classification. Most states use the Model Penal Codes classification for various mentis rea. So mentis is the state of mind for that you would have in a crime. There are four hierarchical categories. So the highest one is acting purposely. So if we're talking about murder, you're going to need to show that he was acting purposely. You know, he wanted to kill the guy. The defendant had an underlying conscious object to act. He wanted to kill the guy. He wanted to murder the guy. He thought he would enjoy doing it. You know, whatever. You know, the more you can prove, the better. But you know, you have to show that he had a purpose, and he was acting on purpose to do it. Then the second category is acting knowingly. The defendant is practically certain that the conduct will cause a particular result. So he may be committing a crime, doesn't really want to murder anybody, but as he's robbing the bank, you know, this person is getting in his way, and he decides to kill him. It wasn't really, I said, I really didn't want to kill him, but you know, he was pulling a gun on me. I would have self-defense ordinarily, but I don't have self-defense because I'm committing a crime, and I don't have a right to kill him, and because he pulled a gun on me. So the defendant is practically certain that the conduct will cause a particular result, so you might get second-degree murder. And you know, if somebody was waiting out in the car, he may also be charged with that under the statute as you know, as an accomplice. Anyway, acting recklessly. The defendant consciously disregards a substantial and unjustified risk. The defendant goes out and he gets drunk, then he gets in behind the wheel of his car. He should know he's drunk. His friends tell him, "You're drunk, don't do it, we'll drive you home," but he insists, and he drives into somebody he kills. He drives into a bus and kills a bunch of children. He's going to be in the national news, and they're going to say vehicular homicide. He's going to be prosecuted for the felony of vehicular homicide. It's not as bad a felony as murder, either second degree or first degree. It's not quite as bad as that, but he'll get some substantial years, maybe 10 years. And so he's going to be locked up for a while. Acting recklessly. So you can see the hierarchy of these things. Then final category is acting negligently. The defendant was not aware of the risk, but should have been aware of the risk. You know, we can't necessarily prove he was aware of the risk. He should have been, though. Okay, so he's a officer, and he's the chief financial officer, and underneath him are accountants, and they are cooking the books. He says he didn't know anything about it. He just didn't notice it. Okay, and he's supposed to notice those kinds of things, right? So he should have known what was going on with the books, but he says he didn't know anything about it. It's not going to wash. He's going to be convicted. You might have the same thing with a man and a wife who file income tax, and the man prepared the document, and the wife knows about the document, and if she can be alleged to know that he is committing fraud, she can be convicted for filing a false income tax statement, just as he is. Sort of like the person driving the car, right? That's another one. Say, okay, you're driving a car and you drive a guy to a bank. He hops out with a gun, and he comes running out with a couple of bags, heavy bags, and having the gun and smoking. And did you realize when he hopped out of the car to go into the bank and he pulled out the gun that he might do something? You should have driven off and not picked him up. Of course, he might have shot you. Certainly, if you wait till he comes out and he's got the gun, he might shoot you if you don't drive him off, and then he'll take your car, kick you out, and that's it. but you know, that's the only way you can avoid that. So acting negligently. So there you're going to be convicted of actually the same kind of crime, even though it was just negligence. But you know, you're probably not going to get as stiff a sentence. But then again, maybe you will. I think with the accountant, there's more of a case for not putting him to too much of a crime. Usually these white-collar criminals are not sent up for very long time periods. The Jeff Skilling and some of the people who were convicted during that big scandal in 2002 involving numerous other corporations as well as Enron were exceptions. They got socked to it. They got socked to the maximum of the statutes that allowed, and it would have been possible to even sock them to more years in prison if Sarbanes-Oxley had been passed when they committed the crimes, but they weren't covered by Sarbanes-Oxley. They were covered by previous crimes, and so those crimes had, you know, there's a certain amount of discretion as to how much a judge has to give a defendant when he's convicted of a crime. So there's usually a lower amount and then a higher amount. And what you get is going to depend upon whether there are extenuating circumstances that make you more responsible, or there are mitigating factors that indicate that you're less responsible. Were you drunk? Okay, is this negligence? Okay, were you just careless? You know, were you stupid? Ken Lay said he was stupid. No, he didn't say he was stupid. He said he did things that were stupid, but he said he wasn't a fool, but he did some foolish things. Okay, what's the definition of a fool, Ken Lay? Anyway, Ken Lay was the chief financial, the chairman of the board, and was not the chief financial officer, but he was there. So anyway, so we have this classification system rather than the old specific intent and mens rea, although these terms still come up to explain the crime because lawyers know them and they just kind of still use them. But there's a different categorization, hierarchical categorization that is used because there are oftentimes arguments about how applying specific intent and that. But you know, in argument you have a certain amount of latitude you can use it still. Malice distinction. A minority of states actually reject the model penal code approach. Instead, they apply 2 levels of malice to ascertain the appropriate liability to apply to those who commit crimes. Express malice, commission of a crime with the deliberate intent to bring harm to the victim. So that would be murder, right? Implied malice, indifference to harm that a victim may suffer due to the defendant's carelessness or inattentiveness. So that would be keeping that dangerous dog and he's escaping from you, but nothing's going to happen, right? We're way out here in the country. Yeah, there's some joggers, but they usually, they'll be fine. So malice distinction. So we make these distinctions between them. Okay. Okay. Criminal liability. Conviction for a crime requires proof of the following elements. Act prohibited by a statute. Formerly, at one time when our nation was first founded, it would be acts prohibited by the common law. So there were common law crimes such as burglary and robbery. These were common law, murder. These were all common law crimes. What the states did was largely to codify the common law. And so if you go to law school, you'll learn about the common law crimes maybe, and then you'll learn about the statutes, and you'll look and say, well, they're the same thing. Yeah, it's the same thing. But however, over the years, there may be some modification in it. Certain nuances are added, certain extensions. So let's wrap it up here. So the act is prohibited by a statute, formerly the common law. So you need that act, you need a statute declaring it illegal. We're not going to use the common law anymore. Mens rea is a specific, there are purposes for common law, but it's not going to be in terms of defining a crime. Mens rea, a specific state of mind or intent that varies from crime to crime. So we still talk about it, okay, even though we got the MPC and we have these malice considerations. Burden of proof. The burden of proof, as I said earlier, was beyond a reasonable doubt. Compared to civil burden for a tort is the preponderance of the evidence, more probable than not. What is beyond a reasonable doubt? Well, a high degree of certainty. Okay. Is it absolute certainty? No, it's not. You don't have to have absolute certainty, but you need some substantial reason to believe that he's committed this crime. And so the prosecutor has the burden of producing that kind of evidence that gives you this feeling that, yeah, I'm pretty certain that he did it. Maybe he didn't, but I don't think so. I think he did. So you might say, I think O.J. did it. Did the prosecution prove absolutely with certainty that O.J. did it? I don't think they did. They certainly put on a lot of evidence, but there were some questions out there, including whether or not he was actually there at the time. That's why the glove was very important. Well, anyway, that was the key thing, tying him to the place. You have to put him in the place of the crime. And anyway, that's it for now. Next time we'll continue this, and then we'll move into administrative law, and into a whole different area. So we've been talking about wrongs, we've talked about civil wrongs, and we've talked about criminal wrongs.